Hello and welcome, everyone. I'm John Miller, founding attorney of Rock Solid Law. It's my extreme privilege to welcome on this webinar with me Gary Thurman and Tim McDermott from Guardian Investment Advisors. We're going to be talking about estate planning and financial planning in a changing world. Obviously, you would have had to have been living under a rock not to notice all the changes going on in 2020. I think many of us will be very glad to welcome 2021 in. Good morning, Gary.
Good morning, Mr. John. How you doing today, buddy?
I am great. So good to hear your voice. Tim, are you there with us as well?
I am, John. Thanks so much for having us on.
Good morning, my friend. My pleasure. Absolute pleasure. So, folks, a few weeks ago, we had a live event, which we were pleased to have, and almost everyone who registered was able to join us. For those of you who weren't, please do know that we had an entire restaurant booked, and we were able to successfully social distance during the event. But we did have a number of people who asked us if we would please repeat the event on a webinar such as this. And so that's what we're up to today. We wanted people who were being extra safe or just who couldn't make it that night to have the opportunity to join us. That being said, we're going to try not to have me be a talking head as I do in so many of my weekly webinars, but to have a true discussion this morning. Gary, what's on your mind?
Man, everything's on my mind. I think you started this thing off proper with saying a changing world. So many things have changed, for all of us in 2020. As I'm looking at some of the changes even today as we speak with a new stimulus package coming out, looks like it just got approved. There's so many things in the financial world, which, ties into the legal world. Man, it's been a roller coaster of a year, John, that's for sure.
I am with you, but I also am aware that Guardian Investment Advisors has weathered the year well on behalf of their clients. And before I bring Tim into the conversation, I just want to say to all of you on the call that these guys have over 30 years combined experience. Their record is extraordinary. I won't berate that point or belabor that point too long, because I'm sure they'd be happy to show that to you if you would like to inquire. They are independent advisors, which means they have a broad selection of investment opportunities. And I don't want to, this is not intended to be a sales meeting, but rather an informational meeting. And I would encourage you, if you are interested in getting more information about them, to contact them after the event. We'll be reaching out to everyone to give you the contact information. For those of you that might be new, I don't know if there's anybody on the call that we haven't met yet, but I'm the founding attorney here at Rock Solid Law, and we practice estate planning, real estate, and represent entrepreneurial business owners. And I've done so with this firm since 1991 and began my practice in, I believe, 1984. So I've got a minute or two at this. Tim, what would you add?
I love that you say it's not a sales call. It's information. That's kind of how we do things. We love to base things around giving the most information out there possible to everybody. And it's the way we do just about everything. If you come into our office, it's probably very similar to coming and sitting down with you, John, and you just sit down, we give you the information and let you make the decisions that you want to make. And I love that idea. 2020 has been a bit of a crazy year. However, I've been very blessed with 2020. I actually got married this year, so that's a big blessing for myself. I've been able to work with Gary this year. So I've had a lot of good things happen to me through 2020. And I know we all see a lot of the doom and gloom through 2020, but there's been a lot of great opportunities throughout this year as well.
Definitely agree with that.
So what we thought we'd do is kind of ask Gary to be the glue that holds us all together. And we've got 4 or 5 topics that we talked about the other night that we'd like to talk about with you guys again today. That's your cue, Gary.
Yeah, that's me. So one of the biggest things that Tim and I like to talk to all of our clients about, in particular situations, are funding a trust. And John, that's really where you come into play. I mean, we feel that a trust is very important, especially if you have a complicated portfolio. But so many people just think, "Hey, I got a will, I'm good to go." We think a trust suits you a lot better. But John, one of the things that can hurt a trust is it's got to be funded. So can we spend a few minutes just talking about funding the trust, John?
Absolutely. Just to follow a little on that, Gary, uh, we will sit with everybody that comes to talk to us about estate planning and determine whether the best course is a will-based plan or a trust-based plan for your family. And ultimately that decision is yours. What you're going to get from me in the discovery meeting is basically information on the options available, and then you'll make the choice, of course, with us educating you. A couple of the things we love about a trust: it keeps the government out of our business. They're private. There's no probate, which is costly, time consuming, and public, right? So one of the things we love about a trust is it allows immediate access to whatever it is you leave behind to those you love. We call that showing your love to those you treasure. So should you determine that a trust-based plan is the best one for you, the very incredibly important next step we refer to as funding. What that means is making sure that all of your estate, all of the things you own, are owned within the trust and not in your individual name. Sadly, I'm dealing right now with a case that's inherited that doesn't involve anybody on this call, where a couple had a beautiful estate plan, but for whatever reason, some of their accounts were in tenants in common, which don't worry about the legal, but they were not in the trust. So one of the members of the couple having passed now, sadly, that estate or part of it is going to have to go through a probate in a state other than Florida. So some attorney somewhere back from their previous history is going to make quite a nice fee because of the way that account was titled. And that's very troubling to me. I literally lost sleep this weekend over that situation, one that I had little control over. So the funding of the trust is moving the title to your assets into the trust. And those, of course, can include your market accounts, your bank accounts, depending on what you have, can be real property, can be other things. So I would suggest that we work closely with advisors like Gary and Tim to make sure that your assets are properly moved. And to not do so, I consider malpractice. I consider it very poor advice from any lawyer who doesn't move your assets into a trust with you after you have created that trust. So I'm sorry, folks. That was a little distracted because I see Tim dropped off.
I don't know if he's still there or not.
I'm looking for him to call back in, and I will readmit him, but he's not on the call right now, Gary. Can you tell that?
Yeah, I can tell that he dropped off there.
Okay.
He'll come back in.
I'll look for him. But, some accounts like retirement accounts, qualified plans, IRAs, some of those, you don't title into the trust, but you make them the death beneficiary.
That's
right?
correct. Yeah.
So from your perspective,
that's what Tim was going to throw in there. Yeah. I mean, that's what we look at, John, is making sure that we make the trust the beneficiary. Because most of our clients out there, most of the money in the United States right now is some type of IRA, some type of qualified money, 401k, 403b. So, that's what's so important about the trust, is making sure that it's set up as a beneficiary. When you get this trust set up with John. And John, something else this is a big topic for me. This is something I talk about all the time, is healthcare. You've got to make sure that you've got the healthcare set up within a trust, because 50% of us unfortunately, 50% of us are going to need some type of quote unquote long-term care down the road. So I think Tim is back on with us now, but having that health care properly set up within that trust is going to be vital for everybody. Don't you guys agree?
I absolutely do. And it's an inquiry I get regularly. It's obviously financial health and physical health are two of the top subjects in most people's minds.
Yeah, Tim, what are your thoughts on that? Make sure we have the health care inside that trust.
Oh, absolutely. The healthcare aspect of this is so important. We talk about income planning all the time. And one of the things that I like to say is you can have that income plan in place and something to help, supplement your life going through retirement. But if that healthcare plan is not in place, it will destroy your income plan by having to pay for, assisted care living or, nursing home care or bringing a care worker into your home. And that's a lot of extra cost that gets added onto that income plan that you've already built.
Yeah, John, I know this is something you and I've talked about. Not liking the name living will. What do you mean by that?
Well, a living will, I think, is the most confusingly named document in all of estate planning because everybody other than lawyers who get our joy out of practicing in this area, confuse the term with the last will and testament. I often have people say, I need to get my living will together. Well, a lot of people do know that a living will is actually your instructions to your last caregivers. It's really the instructions of how you want to be treated during that last illness. I like to call it the ticket to ride. I'm a Beatles fan. So it's your ticket from this life to the next, depending on what you believe is out there. I believe there's something next. So it's a ticket to ride in my book. We actually have renamed it, as I think some other quality attorneys across the country have, as a physician's directive, because it is your direction to your physician on how you want to be treated during that last illness and when you want them to withhold treatments and allow you to pass. Your last illness, it's often said, can be more expensive than the 40 years preceding that illness. And obviously, that can take a lot of assets away from those you love. We love and respect our healthcare providers, of course, and we want them to have clear direction from you on what it is you want to have happen to you, and you should have the say in that. Under Florida law, you do. You can decide how and when certain treatments will be terminated and you be allowed to pass. Of course, that's in conjunction with the healthcare surrogate document where you've appointed someone to discuss your care with your physicians and health team, but the ultimate decision in that physician's directive, which is often called a living will, is you telling them how to treat you.
Yeah.
I'd love to hear you guys tell a little bit about some of the long-term care opportunities. I know I get that question a lot.
Yeah, it's a big deal. Tim, can you just spend a few minutes talking about how someone can protect their spouse from a nursing home spin down with what you and I call our asset-based long-term care plans? I think so many people still don't understand that this is an option out there versus just traditional long-term care insurance. Can you spend a few minutes on that, Tim?
Yeah, absolutely. The danger of traditional long-term care policies is they're very expensive, and it's not necessarily that they're expensive. It's just, are you getting the value out of what you've paid for? And I know folks who started these plans 20, 30 years ago, and they've been paying $1,000, $2,000 a year into this plan for 30 years. Which could add up to $30,000 to $60,000 that if they never get to go into the nursing home, lucky them, right? Nobody really wants to go to the nursing home, but that $30,000 or $60,000 is just kind of wasted. It went to the insurance company and nobody got to see a dollar out of that policy. The difference in what we're trying to do is we're trying to leverage your funds to do multiple things for you at once. We have plans that help take care of the long-term care aspect while also, leaving a death benefit to your beneficiaries if you're so lucky not to use a nursing home or not to need that care. We had a joke going around that if you passed away in your sleep, what we call you, lucky, You didn't have to go into the nursing home care spin down.
Yeah,
You didn't
yeah.
have to go through the pain of having a major illness, right? And so it's great to have that protection in place, but let's try and make sure we do it in a way that helps take care of multiple aspects of what you're doing all at once.
Yeah, and I love what you said in there. Here's the great thing about asset-based long-term care is if you don't use it, which we hope none of you do, the money doesn't get wasted. If you have traditional long-term care insurance, which if you already have that in place, we're most likely going to help you keep that in place. But if you never use traditional long-term care, the companies just keep the money. So that is something, John, that we would love to have conversations with anybody about here in Tennessee or down there in Florida. And here's the big one, guys. Let's throw it out there. The wonderful world of probate. Probate can get ugly. Probate can get expensive. John, spend a few minutes talking about probate and how important it is having these beneficiaries listed and things like that.
Absolutely. And we actually just had a question that kind of dips a toe into the probate. And so I will start with answering that inquiry. Well, the easy one is no, for whatever reason, all you're seeing is me at my desk. We don't have exhibits, and I don't know why Gary and Tim's faces aren't on your screen either. Sorry, you're just stuck with me and a great discussion. But I've got a question. It says, doesn't a pour-over will take care of any assets not expressly titled in the name of the trust, house, bank account, or other investment? That is what a pour-over will is designed to do. It's the safety net in case something's left out. But let me tell you, to make a pour-over will effective, you've got to go through the probate process. I like to call myself an anti-probate device. I will do everything I can to keep my clients out of going through probate. Why? Probate's expensive. Probate is public. Most of my clients don't want the dirty laundry or the skeletons in their closet, or even just the fact of who they left what to and who they might have cut out in public in the court records forever. And it's time consuming. It means that heirs don't get control of the assets for an extended period of time. So I understand. Is your video really off? Oh, you are too funny. I don't know how to correct that.
Sorry.
Oh man. All right. I'll work on that when one of you's talking. Sorry.
Yeah, that's fine.
Yeah. Too funny. Too funny. So yes, a pour-over will put things that you forget to put into the trust. And let me tell you, there are a lot of lawyers that help their clients end up with exactly that situation. Why? Who do you think profits when the estate goes through probate court?
The attorneys.
The attorneys. You're exactly right, man. And I just don't think that's the right thing. If some family really wants to pay an attorney, they don't really know, because it's probably not going to be the one you're working with, assuming you've lived a good long life, to make money off of your estate. Well, that's your choice, but I really can't. I can't recommend that, and there's just no good reason to rely on a pour-over will when you ought to take care of things during your lifetime. And our firm believes it's its responsibility, working with the financial advisors, to make sure that happens.
Yeah, Tim, you want to throw something in on that too, bud?
Yeah, listing beneficiaries is usually one of the best and easiest ways to avoid this entire thing. It's really a minor process that I think a lot of folks forget in some cases. I know personally, as we do planning for folks, we set up these accounts for our clients, and almost every single time it comes with a beneficiary sheet. List out your beneficiaries. Who do you want your beneficiaries to be? We always ask that question. I highly recommend you list a beneficiary. And sometimes we get in a situation where we sit down with a client and they don't know who exactly they want to be their beneficiary at the moment. Maybe they don't have kids. Maybe they're not sure if they want to give it to their nephews, nieces, a charity, or they want to split it up amongst them. One of the easiest ways to do that is to have a trust in place that lists out those beneficiaries, and you name the trust as the beneficiary. And then the trust is the only thing you really need to update throughout that time, instead of every time something changes, going back and changing every single one of your accounts. It's an easy way to do it. It's an effective way to do it as well.
Yeah, I agree with all those things, guys. Good stuff there. Now, this is a big one too. I mean, because, and this gets a little technical. All right. So, do we have a joint account, tenants in common? I mean, John, honestly, when it comes to trust, that's why we depend on you. They can get confusing. I mean, that's just being honest with you. They can get confusing. So, what are the benefits, in having a joint account set up the proper way?
Well, you're talking about specifically a market trading account?
Well, yeah, and built inside that trust. I mean, because
Yep.
if you pass away, it's easier to pass that to your spouse and things like that.
Absolutely. So if a joint account, if there are instances in which an account may be held tenants in common for a good reason. It's often when it's a multi-generational, say a parent and a child, or uh, when it's maybe a second marriage, a later marriage to decide on which assets go to what person. So the situation I spoke of earlier was not that. It was a long-term marriage. But joint accounts should be set up symbiotically, right? If that's the family's plan, and it usually is, so that if there are joint accounts, they flow into the trust on the pay on death or transfer on death language, presuming that's what the family wants to do. And usually that's what the family wants because uh, because that means that the terms of the trust that they've agreed on together can be honored.
Mm. Yeah, and Tim, something that we talk about all the time and I think that really relies on what John was just talking about or relates. I'm sorry. You got to review your plans. I think so many people, especially when it gets to their retirement planning, they get a plan put in place, hopefully, and then they just kind of forget about it. Life happens, divorce happens, death happens. I mean, you've got to constantly be, sitting down with your advisors at least once a year to review your plan because I think things can happen where, Tim, you and I could probably had met with somebody several years ago and they didn't need a trust at the time, but now it's 5, 6, 7, 8, 9 years later and they need a trust, right? So reviewing that plan is very important.
Yeah, absolutely. One of your kids may have gotten married to somebody that you want to make sure that if something happens to your child, the funds don't get passed on to, their husband, and then the husband gets remarried and it goes to his new kids instead of, your kids, the intended beneficiaries in that case. And so lots of things happen throughout life. I do want to go back and put a little bit of an emphasis on what John was talking about with the joint accounts. If there's anything that you can take away from today's webinar, this is something you can take away immediately and go back.
Oh, goodness. I just promoted him to a panelist and I think I might have cut him off. Oh, Tim, I'm sorry. If you can hear
Tim,
me.
are you there?
I'm back. Can you hear me now?
Yeah, that was my error, Tim. I'm trying here.
No worries.
All right.
Can you see
You're
me?
on video now, Tim, just so you know, but we don't see you.
Oh,
It's like, Tim, what were you saying about the joint?
yeah. So there we go. Hey.
There you are.
So one of the most important things that's out there is making sure that your joint account is set up the proper way. If there's anything you can take away from today and take home, review right now, this is something you can do and look at right away and review, is that there are different types of joint accounts out there. And I don't think a lot of folks know that you can have more than one type of joint account. John was talking about tenants in common, which is typically set up to protect the other joint owner should something happen to you litigation wise. One of the best examples I use is, hey, if you're driving down the street and you get in a car accident, your tenants in common, the other person in that joint account is protected because they're in a tenants in common account. That's the advantage to having that tenants in common kind of account. It's also used highly with, like John was saying, a father and a daughter or a father and son type of scenario.
Right.
The joint with right of survivorship is really beneficial when you're a spouse. So you and your wife or you and your husband get together and open a joint account. It's a very easy way for you to take that account and pass it on to your spouse after accounts. There are spouses that do a tenants in common. Your advisor should be informing you as to the differences and why you would do one over the other.
Yeah, that's good stuff, guys. John, I know we had a couple of questions there from Wise and from Rob. Do you want to hit those real quick?
Sure. Yes, thank you. So the first question is, are there special circumstances involved with properties in multiple states? And the example is Florida, Georgia, and Virginia. Absolutely. And almost every client has a special circumstance of some kind or another, guys. People think, oh, I'm just normal, I'm just regular. Well, we all have different life journeys and they end up with different things that folks own. So particularly, I'm going to go with those are real properties from your question. And yes, we have to involve attorneys from different states to make sure those are properly funded into the trust. I'm a real property lawyer, as I mentioned, and I can draft a deed, but I will always have an attorney from the other state work with me to make sure it's done properly there. So with multiple properties, it's kind of interesting. I've lived in Florida most of my life. I was born in Virginia and I graduated high school in Georgia. So you've covered a lot of my life there, sir. So yes, there actually are special circumstances, but they can all be owned by the same trust if done correctly. And I would mention, I don't know which one is your homestead. Florida has an extraordinary homestead law. So it's very important. Any transfer of a homestead in Florida into the trust needs to be done correctly so that we never lose those homestead protections. So the last part is with regard to having heirs or no heirs, there are lots of considerations to what to do at that point. And congratulations and thank you for taking care of your 91-year-old mother. There are special considerations there because, well, we just never know how long our life's thread is, and somehow she needs to be provided for during her life as well. So I see that you just added that you're a Florida resident now. Congratulations. Welcome to the Sunshine State, even during winter. Yes, homestead considerations are absolutely essential that you take into consideration. Either of you want to chime in on anything there?
Well, I'm just glad that you brought that. That was a great question because I'm sitting in Tennessee right now. So I know things are different state to state. So I'm just happy that question was asked. That was a great question, by the way. Tim, do you have anything to add?
You're exactly right. Things will change from state to state because laws differ in that. The only thing I would add to that is if you are new to a state, if you've just moved to Florida, if you just moved to Tennessee, have a lawyer in that state who understands those laws, review your legal documents, let them look over them and make the changes that are necessary for the laws in that state.
Absolutely. Great point.
I love it.
And being in Northeast Florida, we are having an awful lot of people from the Northeast United States and the Midwest decide that it's time for them to become Florida residents. I had a recent estate planning client who said, well, I think he was from New York or New Jersey, and he said, well, we're all required to move to Florida. I just figured with the pandemic, I might as well do it now. So, and I've been surprised at how many Midwesterners are choosing our part of the world right now. I believe it's 65 new residents a day at this point in time, even during the pandemic. I would like to add, as you are, congratulations, you and I came here about the same time, the second time for me. So it says 31 here as of August. So that's not a new resident, but I'm glad you're here now. I would add, I have the great privilege of working with a national network of lawyers who work closely together in many, many different states. So one of the neat things, even though I am essentially a solo practitioner, I have a great web of fantastic lawyers that I collaborate with. And I would just suggest that you need to make sure that whoever you're working with has that available to them. Let's go to this next question, guys. Say that again, please, Gary.
I love that you said that because Tim and I are in the same boat. Just to let everybody know. Can you hear me?
Yes, now. Oop,
Maybe not.
maybe not.
We'll come back.
We'll come
John.
back to that. I don't
Yeah.
know. Do you know which boat you were in, Tim? I think it's because you're multi-state.
You know, there's a lot of boats.
Did you guys lose me?
Oh, we're having a little video trouble coming in, but we'll get back to Gary as soon as he's back online. So the next question is, are you, your existing clients, trust clients, are you making changes for them due to the Secure Act or recommending they get a review? Absolutely recommending a review. And in fact, we reached out to all of our clients to ask them to get reviewed before the end of the year. Just for those of you who might not know, the Secure Act, as well as Rob, the Secure Act is what took our ability to inherit qualified plan funds and spread it the income over the life expectancy. It's been cut down to 10 years. A bit surprising to most observers, I think, because that was passed through a Republican Senate with a Republican president signing it last January. It obviously is an increase in taxes because folks have to inherit those funds sooner and pay taxes on them sooner. I absolutely encourage everyone to get a review because there are strategies that can eliminate those taxes later. And there's one school of thought that says, go ahead and bite the bullet now while taxes are low, pay the tax and convert to a Roth. It's not right for everyone. I'll let you guys talk a little more about that, but everyone should be informed so that the decision they make is an informed one.
Yeah, Rob, that's a great question. Good to see you on here, by the way. Haven't seen you in a little while, but I'm glad to see you're on here. So we're keeping up with a lot of the changing laws. There's a lot of politics this year. CARES Acts are coming out, stimulus packages are coming out, and I think a lot of things are going to change over the next couple of years as well, with a changing party in place as well. So we try to keep up with those, and we review our clients' accounts every single year. And it's a conversation about what's changed in your life. Here's what's changed politically or lawmaking wise, and here's how we may make some adjustments to make sure we keep up with those things.
And throw in there, it's great you guys do that every year.
Hey guys,
We don't need an every year review with our clients necessarily, but when changes take place, we should review. So we keep up with everybody every year, but we try to encourage a review of the estate plan at least every 3 years.
Awesome. Gary?
Yeah, can you guys hear me now?
We can.
Sure can.
Thank you.
Okay. I had some internet issues there. Sorry about that. One thing everything you guys are talking about is so good. And one thing, John, you made a good reference point about having that support group behind you, a large group of other professionals behind you. You noted at the very beginning of this, Tim and I are independent advisors with Guardian Investment Advisors, but man, our team is incredible. We have a wealth of knowledge at our fingertips to help our clients with lots of things like that. And then that's why we also work with people like John, who's the expert in his field. So I think it's important for everybody to sit down and review all of your plans, especially your retirement plans. That's where Tim and I really come involved. Tim is there in Florida. I'm here in Chattanooga, Tennessee. I do come down to see Tim and work with Tim about once a month. But man, this has been a great webinar, guys. Lots of good information. Lots of great questions, actually, from our attendees. So I wanted to say thank you for that. I did want to make one quick plug real quick for John and I. We're going to be doing a radio show tomorrow. Now, the radio show is based here in Tennessee, but it's real easy. If you'll go to Facebook, and there's two ways you can listen into the show if you're there in Florida. You can go to Nooga Radio, Nooga Radio's Facebook page. I'll type that in. Or you can find our personal Guardian Investment Advisor page. We'll share it on that. John, I'm really looking forward to having this conversation with you tomorrow. We're going to cover a lot more stuff as well because we'll have more time. But I just want to make sure everybody knew that. And I'll plug that in and let you guys finish up here.
Thank you so much. I'm excited. And of course, for everyone but my mother, I have a face made for radio. So I'm looking forward to talking with you tomorrow. I would share with you, it's really fascinating. And I really appreciate those of you who attended today because your questions literally led into the subjects we had set out. Tim and I had a lunch conference last week, and he sent an email around yesterday that listed out 5 areas, and the flow has been seamless, mostly because you attendees have asked a question about the next subject as we are transitioning to it, which is a true pleasure. I will say, you know, I've been around a while. I started practicing in the mid 80s. And one of the hard conversations is to get people to even talk about wanting to do their estate plan, because um, it has to consider our own mortality, right? Jim Morrison's book was No One Gets Out Alive. And I'm pretty sure we're all in the same boat eventually. So we like to talk about it as a reflection of your life's journey and your values, and how to share what's yours after you don't use it, if you don't use everything up. Of course, the plan is spend that last dime as you slide in and leave behind a not too good looking corpse, right? But not everybody accomplishes that. And a lot of people have a lot of peace of mind knowing that they provided for those that they're leaving behind. The pandemic's been interesting. It really has. It's been a weird year. Our practice has accelerated this year, and I believe it's because people have realized, okay, I've put this off a lot of years. We've got COVID out there. Let's hope it avoids our family, but what if it does? And the last thing you want to do is worry about that when you're battling an illness, right? So get the plan done, check it off your list, and then come back around periodically and update it properly. Hey, Gary, I don't know, you were typing in. I see that the website for Facebook is on there, but there's a question about the point you didn't get to when you froze. I think it was the multi-state thing, but you take that and run with it.
Well, no, I was going to the point of the fact that, like you said, you work with a group of other attorneys that you can really rely on. You can ask questions to. You can get advice from. I made that point when I came back. Tim and I work with a group called Advisors Excel, and another group called AE Wealth, and it just gives us such a great opportunity as independent advisors to sit down with somebody, have a conversation with them, find out what their goals and their needs are. And we have an array of different things we can do for folks. We just got a heck of a team behind us. So that was the point I was trying to make, Joyce. I just wanted to make sure that everybody understood that, yeah, you're working with Tim and I, which is great. But we have a back office of very, very intelligent people that we can rely on for a lot of different things when it comes to your retirement planning as well. So that's what I was trying to make. That was the point.
Awesome.
So I'd like to apologize to everyone for my technical inadequacies. I've already learned something on this Monday morning. And the next time we do this, you'll get to see Tim and Gary's smiles from the get-go. I would not require you to look at my mug only. And for whoever that was that pointed that out, thank you so much. How come we're only looking at John, I think was basically the question. So I would say to you, any of you that have not yet approached estate planning, or who are new to Florida, or who need to have your plan looked at again, just for being on the call today, I'll absolutely waive my consultation fee to sit and talk with you. We can do that by telephone. We could do it by Zoom. We could do it by any other electronic method. And we are actually seeing people in our office. We are taking very great precautions with COVID, including asking that you wear a mask when you come see me, and we'll sit 6 feet apart. But I'd be delighted to see anyone who needs to pick up your trail on that journey.
John, how can they reach out to you, John?
Yeah, you can call our office at 904-241-1113, or you can go through our website, www.rocksolidlaw.com. Tim?
Awesome. John, have you seen the videos of the cars driving by looking at Christmas lights? And you have one house that has this massive array of Christmas lights, and right next door they have a sign out front that says "Ditto," pointing to the other house.
I love that.
My point is ditto. We would love to meet with you guys as well. We have a office over by the town center where we have a large conference room. We'd be happy to sit more than 6 feet away from you if you'd like. Zoom is always an option for us as well. We'd love to touch base with you guys if you have any questions. comments, concerns, whatever you want to go through, we'd love to sit down and talk with you. We could also meet you at John's office if you're familiar with that is.
That's awesome, guys. Tim, easiest way to get our website, and Tim, I'll let you get the phone number for them to reach you directly. Our website is giaplantoday.com, giaplantoday.com. And Tim, what's the best way for them to reach you, sir?
Yeah, they can call my cell number. It's usually the easiest way to get in touch with me. My number is 919-618-0361. And of course, you're welcome to call our office and talk with Amber or Kim up there as well.
Yeah. So it's been fun, guys. Thank you so much for the opportunity, John. Appreciate it. And everybody that attended, and great questions. Again, this has been a lot of fun.
Absolutely. I had a blast. Good to see you guys, and I'll see you on the radio tomorrow.